Lloyd Russell-Moyle.
Thank you, Madam Deputy Speaker. For £12, disreputable individuals can register UK companies and begin trading arms internationally through a network of subsidiaries. For £12, they receive the legitimacy of a trading company and as a respectable business. And we know this is the case because it's been happening for 10 years, and it quite well could be happening right now. We know this has been happening thanks to the investigative work of Amnesty International and other NGOs that showed in 2014 a company called S-Profit Limited used a Ukrainian-based company registered here and was named by the South Sudanese government in brokering £44 million in small arms to them. Mr. Speaker, the South Sudanese government is subject, Madam Deputy Speaker, is subject to sanctions, and yet, astonishingly, the company, S-Profit Limited, is still a registered British company. In 2009, the Committee for Arms Export Control found that a company, Hazel UK, had been brokering arms to Libya, Syria and Sri Lanka, which at the time all violated sanctions against those companies. Those countries. This company is still registered. I could go on. Systems Use Contracts Limited brokered arms to Rwanda, etc., etc. I've got a long list here. And despite this wealth of evidence, these companies are engaged in sanctions busting but are still registered as British companies. Well, why? Well, it's partly in the name. They are, of course, brass plate companies, meaning they have no staff, no real office buildings and no real assets based here. Today I received a letter from the Minister himself recognising that it is difficult to investigate and collect the necessary evidence to reach the threshold of prosecution. Those were the Minister's words, not mine. So if we wanted to conduct criminal investigations into these companies, they couldn't bring suspects for questioning, raid offices and buildings and seize assets. And equally, the sanctions that we currently have in place are mainly about freezing assets, travel bans, which have no impact on these particular companies. One of the other things that the Minister responded to me in the letter is he said that current sanctions are as temporary measures, not as long-term measures. Well, the Customs Powers Act 1979, which is where this bill derives many of its enforcement powers, allows for the destruction of goods. It allows for the resale of goods. These are permanent acts. You can't undestroy a good, Madam Deputy Speaker. And of course, the amendment that I am putting forward allows for a 7-year appeal for any company that would be shut down. It allows for compensation if a company is shut down incorrectly. It allows for a temporary measure to be reversed if the wrong decision was made. I will do.
I thank the honourable gentleman. Thank you, Madam Deputy Speaker, for allowing me to intervene on him. I'm intrigued by this. So, fundamentally, the honourable gentleman is saying there's a brass plate and there's a registration in Companies House, and then actually there's nothing between that and a company working abroad. There's no connection at the moment. There's absolutely no way they can be traced. Or have I got that wrong?
It's not about tracing, it's about that they use the British registration, but they do activities through a set of subsidiary companies or other companies abroad that they are linked to then take part in the nefarious activity. The individuals might be directors on both companies, for example. At the moment, the threshold of requirement to disbar those individuals or strike the company off is of a criminal level of responsibility. That level is just far too high, and if the level was brought down to a more civil level of responsibility, the Minister would be able to take action. Now, if the Minister feels that he wouldn't want to take action, I'm not compelling the Minister to take action. I'm giving the Minister those powers, if need be, that already exist in the Insolvency Act. So it's not about extending powers that have never been used before. Now, I know the government says that there isn't information at all about these companies. Well, let's look at S Profit Limited, a UK-registered company brokered arms to the South Sudanese government. This government has received copies of the contracts involved. The Ukrainian directors of that company have even admitted that the contracts were genuine, as did the Ukrainian state company responsible for brokering the weapons. It's not enough for criminal action, but clearly this is enough for a minister to impart the public test of whether this company is acting against the public interest, whether they are breaching sanctions, and they should be struck off so they can't use the brand Britain as a front for their company. Now, Sir John Stanley, when he was in this place, recommended these same powers in the Committees for Arms Export Control. I'm not trying to bring in something that is hugely controversial. The government has already today said that generally they would like to take action on these things. I was really disappointed that we weren't able to get the government to just support this, and I did try and meet with the government a number of times, even coming up in recess to try and meet the government and then cancelling the meeting 20 minutes before it was due. So it is a real shame. I would like the government to give way, but I won't push this to a vote in this occasion if the government makes a commitment to look at this further, to take this on, and which I think that they have done today, and I hope we can work together on